I really we all want to thank two advocates, Ted Cruz and Michael McConnell, who did such a good job that we spent the first 5 minutes talking about how well it was argued, and we've always seen so much good advocacy here, and we all thought it was a really splendid display. Law, we have some gifts for you. The Supreme Court itself is going to start this tradition. These are your, it hardly, I'm sure, makes up for all the hours of preparation that was obvious in the arguments, but it's something to take home.
Like
so, we will reveal our vote here, but first I always like to give the disclaimer for the few reporters on the bench here. We're not voting how we think the case should come out. We're doing this as an educational exercise, and you'll see by our vote and the number of opinions that will be read this evening that actually we think this is going to be highly educational. The vote ended up being 6-3 in favor of the state for reversal. And the vote broke down this way, and we'll have individual justices actually reading their opinions in a second. But voting for the state to reverse were Justices Braven, Cooper, Dwyer, Larson, Savage, and Van Alstyne. And voting to affirm were Justices Liptak, Greenhouse, and myself. And we're going to have Justice Savage first read for the majority, and then there'll be 2 concurrences read, and then we'll have a dissent and a late PS before we open it up for very brief questions. Justice Savage?
I would read the opinion had I written one, but it was argued, and to my surprise, that we don't think it makes a lot of sense to say that the state can strictly regulate sexual material involving minors, but somehow violence is a completely different category. The only thing you can say for that is that the Supreme Court has said it for a long time, that it doesn't seem to make a lot of sense. Ginsburg seemed to say that there is a different standard for minors. The state can regulate material that's damaging, hurtful to minors. California had a fair amount of evidence that these violent games are new, exceedingly violent, and we think it's a reasonable thing that the state can regulate violence for minors.
And we have a concurrence first by Justice Cooper.
I too will not read an opinion, but I will concur in the judgment to reverse the decision below, and remand for the application of the intermediate scrutiny test. The court below applied strict scrutiny. I have a lot of sympathy for counsel for the entertainment video game industry, Mr. McConnell, having never had the opportunity to consider the O'Brien test and whether or not this particular form of speech is actually a inextricably intertwined form of speech and conduct, and whether or not that has constitutional significance. I have sympathy for his predicament because I am in the same predicament. There was no briefing on this subject, and I've had only 10 minutes more to think about it than Mr. McConnell had. But because I'm not a real justice, and I don't have to be confident of my position here, and reserving my right, when I try to write this opinion, to join my colleagues who are going to reverse the case outright, I will concur in the judgment on those grounds.
Thank you. We have the final concurrence.
Well, I do vote to reverse to remand. An issue that was raised in the course of the argument presented a factual lack of clarity, which I think would be appropriate for the lower court to clarify in the first instance. And that has to do with whether or not, consistent with the statute, the parent of the affected purchaser, the minor under the age of 18, as I recall, or 17. It was conceded, apparently, that consistent with the statute, if the parent wants to accompany it, the minor, and purchase with the minor being present, and then immediately commit the interactive video game to the minor, the statute did not forbid it. My question, which could not satisfactorily be answered either on the record we saw nor pursuant to questions asked here, that I think would be appropriate to examine on remand, is to determine whether or not there's such a thing as blanket consent that can be simply signed. The equivalent would be, as many may know, that a parent with students in school may have to give written consent for the children to participate in certain activities. It is unusually the case that every time the activity is scheduled, they have to sign on again. It's rather commonplace that you can give blanket permission that covers the semester for a certain described swath of activities. They may be narrow or wide. An unknown question in this case is whether it's deemed consistent with the statute for the parent to give a kind of blanket consent so that the minor to whom such a sale of interactive video is otherwise prohibited may nonetheless sell it to that minor as long as they're able to present the written authorization of the parent, whether it's for the particular interactive game or whether it's a blanket permission. That seems to me a factual question that is not clearly resolved in the record, was not satisfactorily examined nor answered below. It is appropriate for the first instance for the lower court to determine as to whether that would then provide an occasion for the case to be reconsidered. Here is not for us to determine prematurely, but that is an issue that seems to be suitable to suggest ought to be examined on remand. So on that basis, I concur in the judgment to reverse, but with instructions to remand for a determination of that particular question.
Thank you. Justice Liptak will announce will speak for the dissenters.
I respectfully dissent, but I have to say this is a dark day for the First Amendment. The justices of the majority have managed to make a simple case very complicated. Just last term, we said we would not be creating new categories of speech outside the protection of the First Amendment. We were unwilling to make criminal the depiction of actual harm to actual animals, quite brutal harm, but now we're willing to protect Super Mario. We believe that strict scrutiny applies, that this statute must be struck down, that we should trust parents and not California legislators.
Thank you. Justice Greenhouse.
I join Justice Liptak's dissent, but I would offer my own dissenting opinion and suggest that the Ginsburg against New York precedent, 1968, this court has expressed a more nuanced and more complete understanding of the First Amendment in those intervening years, and in the appropriate case, I would certainly be willing to reconsider the case of Ginsburg against New York and find that full First Amendment protection applies to sexually explicit material for minors.
Thank you. And again, to Mike McConnell and to Ted Cruz, thank you very much. I'm wondering if Neil or Melody is around, if we should try to stay on schedule and we should just end it without questions now. Are we close? What do you think, Dave?
I think you've got a couple of minutes.
Okay. Let's see if there are any questions, actually.
What was the majority standard? What was the majority standard?
Like Ginsburg, rational basis.
Reasonable basis?
Rational basis.
Like Ginsburg.
On the First Amendment issue?
Hey. Yes, Lyle, 6 people up here. That way. 3 of us didn't.
Wait a second, I would apply substantial relationship.
Right,
I detect the smell of something smoking in here.
Lyle, I said intermediate scrutiny.
Yes, you did.
Does anybody else have a question?
Well, I have a different answer.
Yes.
I think we were unconsciously, without articulating it, thinking in terms of so-called intermediate standards. On the other hand, because of another comparison, some degree of mere rationality might have been argued in this case. It was not. I don't believe that this court or the lower court used that very laid-back standard. But the argument did make the observation that this dealt with the commercial sale of a product to individuals. And if you look at it that way, if you look at it as a product being bought and sold to minors, then you might worry about a different group of cases entirely. Those are cases involving statutes, for instance, that will restrict the sale of certain kind of contraceptive devices birth control devices, family finances, dildos, sexual stimulants, and other things. So if you look at the purchase of interactive video as the purchase of a physical implement meant to satisfy you in certain particular ways, then you may very well assimilate this into a more modest profile of substantive judicial review, which is probably the sale of commercial products of a certain prescribed kind to people below a certain age. If then you liken it to the sale of matches or something else, we're in an entirely different profile analysis and barely inside the First Amendment at all. So if the case had allowed time for that widening, it would have been feasible, I think, to couple in this alternative view, that this is the sale of a given kind of product that's restricted from purchase of minors without parental consent, and it's more akin to those kinds of cases that percolating through the lower courts that have to do with restriction by age groups of certain kinds of simulated appliances.
Great, thank you so much. Dave is giving me the signal. What do you think, Dave?
I think we ought to move on.
Okay, great. Thank you again, everyone.